Dear colleagues, members of the public, and dear candidates, greetings to everyone. Advisory group of experts that's gathered in full composition to interview the next candidate for the position of a judge of the Constitutional Court of Ukraine, Madam Oksana Volodymyrivna Shcherbaniuk. She's a professor head of the Department of Justice at Yuri Fedhorovich Chernivtsi National University. Sorry, maybe I didn't spell it right. And she was admitted to the competitive selection by the Verkhovna Rada of Ukraine. The interview will be moderated by the Secretary of the Advisory Group of Experts, Mr. Yaroslav Romaniuk, and I'm passing the floor to him. Please, Mr. Secretary, you may proceed.
Thank you, Mr. Chairman. Good morning, Ms. Oksana. Greetings to all people who are watching our live streaming of the interview for the position of a group of a Constitutional Court of Ukraine, Ms. Oksana Volodymyrovna Shcherbaniuk. The advisory group of experts had gathered in full interview with the chairman, Mr. Ales Zalar. He is present online. Physically, we have here the AG members Ms. Hanna Sukhotska, Ms. Maureen O'Connor, Ms. Natalia Kuznetsova, and Ms. Oksana Vasilchenko. AG member deputies are in attendance, namely Thomas Griffith, Mr. Richard Barrett, Mr. Marek Zubik, Mr. Vasil Shakun, Mr. Volodymyr Kuzmenko, and me, the AG Secretary Yaroslav Romaniuk. Ms. Oksana Volodymyrovna, we had time to collect the information on your candidacy, and we are really grateful to you for your communication and responses to the written questions posed by us. Today, during the interview, we would like to clarify some of your answers that were not completely clear to us, and we would like to provide you with an opportunity to debunk or clarify any doubts regarding your good moral character in front of the AG. Please note that the candidate may not provide information, documents, or other materials during the interview if the advisory group requested their provision earlier and the candidate did not provide them within the specified period, or if the candidate could have provided them on their own initiative earlier. I also inform you that the interview is being recorded and streamed live on the AG resources and the website of the Constitutional Court of Ukraine. Therefore, I call upon the AG members and the candidate to limit the use of sensitive data and limited access information on live air. In case we have to discuss such sensitive data, we will stop the streaming and we will discuss it only in the offline mode. I would like to draw your attention to the fact that the interview will last approximately 1 hour, and that time limit for responding to a question is 3 minutes, so please be concise and laconic for each question. The advisory group members, international experts, are not Ukrainian-speaking, they are English-speaking. So, there is simultaneous interpretation provided, and you have the headset. You can use the headset if needed. Please, I draw your attention to the fact that blue light means Ukrainian channel, so use it if needed. Also, at the end of the interview, you will be given an opportunity to pronounce your closing statement up to 5 minutes. Now we're ready to start the interview, and I will start it as rapporteur on your candidacy. Let's start from the next question. In your motivation letter, we notice several sentences that coincide with this thesis of Doctor of Law and former chair of the Constitutional Court of Ukraine, Stanislav Shevchuk. How would you explain this situation, that being a candidate for the position of a judge of the Constitutional Court of Ukraine do not motivate by yourself your desire to hold this position, but you take these motives from thesis of the former chair of the Constitutional Court of Ukraine? Dear Yaroslav Mikhailovich, thank you so much for your question. If you look my previous motivation letter, it also contains thesis about the fact that judges should understand Constitution not in abstract way and to be accountable in front of the society for their decisions. And this thesis is repeated many times even during conferences. It is like general idea. It is in the decisions of judges. It's not idea authorized by Stanislav Shevchuk. This is recognized idea that also was stated in his thesis. This is just constatation of the fact, because I think that judges do not work in the vacuum, and the Constitution is not just a formal document. Ms. Oksana, do we understand you correctly? So you say that you haven't copied from motives from Stanislav Shevchuk, just your motives coincide with the motives stated by him. Not only by him, there is the whole direction who follow this idea. He's not the author of this idea. Seriously, I haven't addressed this thesis. It was our conference, but I had no need to look at this thesis for my motivation letter. Okay, in your opinion, how it can correspond and how it can be evaluated by the external observer, if this observer sees that these ideas are common in you and the ex-chair of the Constitutional Court? I would say that in the motivational letter where there is this sentence, I was talking about the role of judge in the modern society. And also there was my motivation. This is the vision of the role of a judge. This is your vision of a judge. Like laterally coincides with thesis of Stanislav Shevchuk. We are talking about the 4 words. There are 5 words in the first sentence and 4 in the second. In your answers to the written questions to the advisory group of experts, you indicated the following. You said that motivation letter is not a scholarly work and contains no new research results, as it explains the motivation, goals, and interests of a candidate, as well as views shared by them regarding their participation in a particular competition, and does not imply any reference on new author's development or recommendation. Moreover, no regulatory requirements for writing a motivation letter were established. So does it mean, in your opinion, that it is permissible to copy someone else's thesis word to word without citing them? It doesn't mean. I haven't copied the thesis. There were just a coincidence, so in future I will check my works. Yes, so you say you haven't copied, it is just a coincidence. Your words coincided with the words from the ex-chair of the Constitutional Court of Ukraine. Okay, in your answers to the written questions of the advisory group, you indicated that in 2017 you conducted a study, Conceptual Principles for the Implementation of Elements of transitional justice in the national criminal justice system in the context of European standards. And your contribution included working on the first part of this subsection. This paper contains some coincidence with other materials published online and relating to the year 2015, so 2 years before. In total, there are entire paragraphs of coincidences, and this is despite the fact that your contribution was 8 pages long. How can you explain this? We can show on the screen these coincidences. So on the left, we see your words, and the right column and the coincidences are in red. So I would like to say that such a subsection, as far as I remember, I was a co-author. So from the very beginning, I would like to draw your attention to the fact that this is about the criminal justice, and it wasn't my topic at this period. It was co-author. It was separate. You see, the text was finalized by my co-author, and I stated it in my explanation. Ms. Oksana Volodymyrivna, then I have another question. At first, you haven't said that this is co-authorship, but after the fact that we have found this fact and asked you to explain it, in response to written questions, you indicated clearly the pages of your text, and after the fact that there were some coincidences, you said that there was co-authorship. Can I explain? Yes, I just passed part of the text that was finalized by my co-author. And by the way, in the table, in the name, you see that it is written by 2 authors, and my co-author is in first place. How there were theses from report that I haven't seen before, I don't know. About the year, the subsection has been, the subsection was done in 2015, but the monography was published in 2017. That's why I believed that it was just relevant text. So it's really very pity for me, and for the next time I will deal with it. Okay. When we talk about your other written responses, you indicated that the training program is not an author's text, but a summary made by the compiler of excerpts from the text to explain the context of individual program sessions and examples. So it is unclear whose copyright has been infringed. So here is a question. Do you believe that it is permissible to copy someone else's text without giving any references to it if it only mentions the compiler and not the author? I think it is not permissible, and I haven't copied this text, because when there was information about the referral and about the coincidence, I have never seen the program sessions, and I have never used it before. Ms. Oksana Volodymyrivna, why do you have such a selectional approach to citing? For example, in your article with Ms. Ovcharenko, there are referrals to the Constitution of Ukraine, but there are no referrals to some other sources. I think this was a mistake, and now I do not do such mistakes. Okay, next question. For example, if we take the decision Velasquez against Honduras, and here we talk about it in a row of scientific articles, but there is lateral coincidence with the text as the results of training in Sarajevo. Have you recognized the copy? No, I haven't copied this text. I haven't seen it. Okay, next question. This text was published in 2016. Your article was published in 2017, and you understand you recognize it. If you do not recognize, then and which language you found the original of this decision, Velasquez against versus Honduras? The phrase of Ukrainian language is not literally translation from the text of a judicial decision, Velasquez versus Honduras. How it could be that your translation is not a literally a translation from the text of decision, but of other publication? I repeat, I haven't seen this report and the results of the training, and I haven't seen this text because finalization of this text was done by my co-author, because she thought that she has more experience in this regard. The advisory group also analyzed the section entitled Legal Liability of a Lawyer from 2021 collective monograph Tort Law Studies. We also found excerpts from Viktor Zaborovsky 2017 dissertation in this section. Although some of your work contains references, none are found in part of its text. Also, there are excerpts where you literally quoted Mr. Zaborovsky, but referred to primary sources that he had also referred to. What's your opinion on such action? Please let us see on the screen what we are talking about. Mr. Yaroslav Mikhailovich, I have already explained, and I have sent you screens about the text sent of the section to this collective monograph, and finalization and screen from the email of co-author I have sent. So do you agree that you copied the phrases from Mr. Zaborovsky? I haven't copied the phrases, I made generalization. So then how can you explain such coincidence? How can I explain? I think that in future I will check the finalized version by myself. You say that you wrote the article with the co-author and it was possible her who plagiarized it. But if we take the previous site, you made similar arguments. So it appears that you have repeatedly collaborated with people who engage in plagiarism, isn't it? Why don't you check the authenticity of works that you are co-author of? After all, it's about your reputation too. I completely agree. And now I'm trying to do it by myself and to check it for a couple of times.
I check the coincidences. Do you understand that co-authorship with people who use plagiarism without citing doesn't characterize you from the best side as an honest person with integrity who should become a judge of the Constitutional Court? Do you understand it? Yaroslav Mikhailovich, I understand it. In this case, why did you allow the cooperation with such co-authors? I trusted people, probably. Okay, let's continue. We also found evidence of plagiarism in your article for 2019, Human Rights and National Security, Problems of Ensuring Them by the Constitutional Court of Ukraine, published in the collection of materials from the International Research and Practice Conference, Human Rights and National Security, the Role of the Constitutional Jurisdiction Body. Some fragments of the text were borrowed from the monograph, Constitutional and Legal Principles of National Security of Ukraine by Mr. Antonov for 2017. Also, in your article, European Standards of Access to Legal Practice, borrowings from the dissertations by Serhiy Ivanitsky, Tatiana Vilchuk, without appropriate references were found. In your written explanations, you already indicated that you were referring to the European Union Directive, which is a commonly known source of law. At the same time, the quotation from the EU directive was just one of the borrowed fragments. Other fragments were not excerpts from the directive. We can display, if needed, these fragments on the screen for you to see it. How can you explain this? Dear Yaroslav Mikhailovich, I was looking through this article, and there was a reference to the two authors. Probably I made a mistake there, but as far as I know, the collection of materials the article was published in was also checked against plagiarism. In your opinion, Oksana Volodymyryvna, if you assess an information as a generally known, like in this case the EU directive, can you word by word copy it from the works of other authors? No, it's not allowed. We found specific quotations in only some of your works. Would you tolerate such borrowings if you had found them in your students' works? No, of course. For several years, we have been having very high standards and strict requirements as to the students' work. Okay, Oksana Volodymyryvna. Let's start another block of questions. In August 2022, in Poltava, a Congress of Representatives of Law Universities and Faculties took place. It elected Dmytro Lukyanov, a new member of the High Council of Judges. At this Congress, you chaired its counting committee. At the same time, in 2021, Mr. Lukyanov was a member of the selection committee for the election of a judge of the Constitutional Court of Ukraine and voted in favor of recommending you for this position. How can you explain this ambiguous situation? Don't you see here any conflict of interest? He supported you 1 year, then second year you supported him. I would like to clarify this situation. First, I didn't see how Lukyanov voted during the competition. I took part and 15 other candidates were allowed to participate in the selection. Do you know each other for a long time? No, we only met several times during conferences. I didn't communicate with him. I just knew that such a scientist existed. So no, we don't have any friendly relationships. It's a scientist, a researcher, and I knew that he worked in the National Law University, and he was a member of the commission. So you didn't know how he voted when you were participating in the selection, and you think it's not a conflict of interest. I will explain. First, these were not public votings. Only later I could see the protocol on the site, and as to the procedure for establishment of counting committee, I would like to indicate that the counting committee is not a disciplinary or qualification body. According to the law on prevention of corruption, the nature of the counting committee is completely different. The counting committee is chosen among the delegates, and the 5 people. So again, according to the law on prevention of corruption, you don't see any conflict of interest here. According to the law, there is no conflict of interest because the members of the counting committee are not members of the qualification or disciplinary committees. In your opinion, once again, from the point of view of a reasonable observer, how can it be perceived that in one selection committee, Lukyanov supports you and another time you support him? A person who doesn't know such specifics, the counting committee doesn't announce a winner. The counting committee, by conducting an open calculation of votes, the secret ballot was done in the presence of activists, and the counting committee counted the votes, then included into the protocol who voted against, but the counting committee didn't decide on the results because the decision about the appointment is made by the Congress, and the protocol was only transferred to the chairman. Okay, that's what I wanted to know. I will quote part 3 of Article 13 of the Law of Ukraine on the High Council of Judges. The candidate is considered to be appointed if, according to the results of secret ballot, he got the majority of votes among the delegates of the Congress, representatives of higher educational institutions and scientific institutions. In other words, if 100 delegates is chosen, a delegate is considered to be decided on if he received the necessary number of votes. It was time when the war was ongoing in Ukraine. Not all the delegates came to the Congress, and let's say 80 delegates came and 45 voted. So the majority, but not the 51, according to the law on the High Council of Judges. You was the head of the counting committee at this Congress. How did it happen that a person who didn't get the required number of votes, according to the law, was declared to be a winner, took an oath, and was appointed to a position of a constitutional body? I, as a head of the counting committee, transferred the protocol to the chairman, and the decision on the appointment was taken by the chair. The counting committee doesn't approve decisions like that. Okay, your answer is clear. In 2013, the president of Ukraine, Yanukovych, appointed Tupitsky and Kosminin. In 2021, the president of Ukraine, Zelensky, issued an order which cancelled the order by Yanukovych from 2013 about the appointment of Tupitsky and Kosminin to the position of judges of Constitutional Court of Ukraine. It became a basis to the following. In a month after this order, competition was selected to fill this vacant post, allegedly. In 2 days after the order by the president, Mr. Tupitsky contested it. And the legal circles were aware of this situation. They were closely following these events. You agreed and participated in the competition. Could you please explain us, as the candidate for the position of the Judges of the Constitutional Court of Ukraine, you must have understood that the grounds for firing these judges, and speaking about any judge, we cannot fire them by canceling the order related to their appointment. It can only be done according to the procedure provided for by the law. Mr. Tupitsky, not only he contested this decision in court, he continued to go to his working place. The media were following it and covering this story, so there was a conflict. And in this situation, you as a candidate who clearly understood the constitutionality or not of the order of the President of Ukraine, so you understood that it was not according to the law, but you participated in this election. How can you explain this willingness in that situation to run for a position of the judge of the Constitutional Court? I would like to divide these two matters, the order of the president and the firing. I was saying the firing was the grounds for the further selection process. Do we really need to divide them and treat differently? As a specialist in constitutional law, there is a principle of presumption, and the act is considered constitutional if Constitutional Court doesn't decide otherwise. So I decided to try my chances, and I already stated during the interview that only after the mandate of a judge is finished we can speak about the appointment of new judges. That was the Constitutional Court did, because the winner of the selection, appointed later by the President of Ukraine, took an oath only after the mandate was of Mr. Tupitsky and Kosminin ended. Okay. Now I would like to ask my colleague, member of the AGE, Ms. Marina Corner, to join this interview, please.
Thank you very much. Good morning. We're going to turn our attention now to some questions that have lingered with regard to property, right? So I'm going to turn to the issue related to 2011, when you purchased a new Volkswagen Polo. In your declaration, you indicated you didn't know the value. So please explain why you wouldn't know the value of this car.
Дякую.
Thank you. I explained it. Indeed, I bought this car. I took a credit. I don't know the cost because we didn't preserve all the documents about this credit. The only document I had, I submitted to the AGE, the fact that I fulfilled all the requirements of the credit agreement. And I didn't remember the exact price.
You understand that this committee, the advisory group of experts, is charged with looking into all aspects of the candidates. In other words, your life and your finances are an open book, as well as your professional career and education. So that's why we're asking, or I'm asking questions about your finances that I think are very relevant. You say that, you know, you had the money, you borrowed it, you took care of your obligation to the creditor, and it's over and done with. So are you saying that 100% of the cost of the car was borrowed from a creditor. Is that your statement?
No, I explained there was the first installment in the amount of $5,000, and the rest of the body of the credit and the interest were paid during the following years.
So let's focus on where the $5,000 came from. You were officially employed, from 1998 until now, you've been employed by the Yuri Fedkovich Chernivsky National University, correct?
Так, все верно.
All right.
Yes, right.
You've been receiving official income in the form of a salary, and according to the information, you stated that you had cash assets saved at home, which allowed me to make the down payment and the purchase for the vehicle on credit. Okay, however, from 1998 to 2011, your income before taxes was 242, almost 243,000 hryvnias. How did you succeed in saving $5,000 at that point to make a down payment of that size on a car, which we are still questioning what the balance was, but answer the first question, please.
Thank you very much. I submitted the price of the currency since 1998. The exchange rate was changing. It was 2.57 at some point. So we bought foreign currency and we accumulated funds for 13 years.
Accumulated funds for 10 years? Is that what you're saying? You accumulated foreign currency for 10 years in order to save enough money to make a down payment. Is that true?
Так, звичайно.
Yes, yes.
You said we. Who's we?
Ми це
I was accumulating funds, but my parents helped me to repay the credit when I was in difficult circumstances.
The source of your parents' income would also be foreign currency investment, and that's how they got money to help you? Because, you said we saved up, and I presumed this was all your savings, but now you're saying that your parents were involved. So, which is it?
Так, долучалися батьки.
Yes, they were involved in the repayment of the credit. Of course, the salary was in hryvnias and the credit was in hryvnias, not in the foreign currency.
And how much did your parents help? You had a balance, although you're not sure of how much, or you haven't represented that. How much help did your parents give you during the period of repayment?
I haven't preserved the documents, but a couple of times they helped to repay when the situation was difficult. I mean, to repay the loan and interest on the loan.
Would you say that they made half of the payments for you? One half of the payments for you for the duration of the loan? Would that be a fair statement?
I can't say, I don't remember whether it was half, but there were some funds that my parents gave.
What's the source of your parents' income?
My father is a retired military serviceman. At that period, she had a pension 800 equivalent to 800 US dollars per month.
So you would agree that your salary didn't meet your what you considered your necessities. In other words, the salary you were on, repayment for a car was difficult, and in 2000, you received a gift of an apartment which was valued at 13,425 hryvnia. Explain who gave you the apartment and why the price was so low.
I received the apartment according to the donation agreement from my grandfather on my mother's side. About why it is so low? Because you see the statement number 3, and I am not the subject of the evaluation. My grandfather was not also subject of evaluation. I don't know how it was done, and I don't know how it was re-evaluated.
The declaration for the evaluation.
Бюро технічної
The Bureau of Technical Inventorization in Chernivtsi region. This is a general and official bureau for the evaluation procedures.
Okay. In 2020 declaration, you did not indicate an income of 900 euros from the Pravo Justice Project. Is that correct? All right. You also didn't provide this information at the first AGE's request, and only indicated that you had received the income from USAID after questions were asked. Is that correct? You weren't forthcoming with that information in the first answer you gave to us. Okay, why did you first conceal this information? What was your reason for not reporting it to us initially?
Я не
I didn't hide this information because if we talk about USAID, this is HDIP, it was the administration of the amounts that should be declared. As for Pravo Justice, I addressed the expertise français to provide constructual information about the term of the contract and about the fund base. In that year, I haven't presented this information because it was done. So the declaration was done in the September of this year, and the payment were in the end of the year. So I, as subject of declaration, I declared it in September, but I was paid in the end of the year. So I didn't want to hide this income.
That's your position for the 2020 declaration of why you didn't inform us of the 900 euros? You're saying you just got that in September of last year? Am I understanding correctly?
пані
Miss Marine, according to the statement from Pravo Justice, I found out what was this income. I took the statement from the bank when this sum was accrued, because I didn't remember in the declaration at the moment of declaring it was the 6th September 2020, and this sum wasn't accrued at this period. That's why it wasn't paid. That's why I couldn't indicate it in the declaration.
How often do you have to do a declaration?
I presented this declaration only as a candidate for the position.
податки
What about tax return? Because if you have income not on your main employment position, if the tax agent doesn't take taxes from me, I declare it in tax return. I worked with US8 and the administering agency was HDIP and they pay taxes. And now with Vilnius University, it is written in the agreement that they pay tax. So when there is no taxation, there is one way of dealing with it.
The source of the income takes out taxes, then obviously you don't have the obligation to pay more tax. We understand that. But the $900, or excuse me, the 900 euros, you're saying that you did pay taxes on it?
відповідно
According to the contract documentation, you have the statement and you sent me an inquiry. What is the income for 2019-2020, including this 20%? We will see the sum that I was paid. And I have the statement from the bank that confirms this information.
What you're telling me is that you received $900. There's documentation of $900, but there's no documentation of taxes, or is there?
I repeat, you have information, you asked me this question in written round, that in the period from 2019 to 2020, according to the conditions of the contract with the Pravo Justice European Union agency, I obtained an income. That's why I presented declaration from Shcherbaniuk. What was this sum? So they took the tax from me, and you can see it from the difference of paid sum and contract sum.
That's for your 900 euro income. All right, according to the information from the State Register of Individual Taxpayers on the source and the amounts of accrued income, your income from the state enterprise GDIP was 54,540. And why did you declare a smaller amount of income?
€40,000 в нас. Ага.
40,000 hryvnias in HDIP. I indicated according to the sums I was accrued and I was paid on my account. I didn't want to hide. I just took the statement from the bank. They accrued this sum and paid to my account, banking card, and I didn't want to hide any information. So you can see it from the statement that these were paid to me, these funds.
Okay, so you're saying as of the date that you were required to pay taxes for that year, you hadn't been paid everything that you were owed from the state enterprise. There was a balance still owed to you.
Я стверджую,
I say that SE HDIP is the subject that administers and calculates and takes fees if they are accrued by chemonics, new justice.
In 2022, you received 2,700 in income from the research service of Verkova Radna of Ukraine, but you didn't indicate that income in your declaration. Can you explain that?
Так, можу пояснити.
Yes, I can explain. This is a technical error. And I don't have. So I recognize that this was a technical error. I didn't want to hide these 2,700 hryvnias.
It just slipped your mind. You forgot about it, and so you didn't declare it.
Я по-
I didn't pay my attention. It is my fault. It is my error.
All right. And the other discrepancies that I talked about, they're not discrepancies. They're not errors. There's no irregularities. Is that what you're representing?
I filled in the documentation based on the bank statement about what I was paid on my bank account, and I imported the information, filled in the information from bank statements.
Okay, thank you. Nothing further.
Оксана Володимирівна,
Miss Oksana Volodymyrovna, you cannot fail to understand that if you have additional income not on your main employment place, they should be taxed. And to avoid such problems about forget, etc., it is better in February each year to obtain a document from tax service. It is not a difficult thing. You can do it in electronic form, and you will see your incomes, and you will see which of them are underwent taxation and which of them not. Also, I would like to ask you about the gift, apartment gift in 2000 year. Who the person who gave you this apartment? This is my grandfather. This is the father of my mother. This is my grandfather. I presented all the documents. Thank you, it is clear. So you obtained an asset as a gift, an apartment. Who paid taxes on this contract? There is 0 tax rate on the gift agreement. So it wasn't paid neither by you nor by your grandfather. So these 13,425 hryvnias didn't influence any income to the state budget. Yes, this is the gift agreement between close people, and according to the legislation of Ukraine, it is 0%. Are there any other questions from the AGE to the candidate?
Question with
запитання
regard to
голови
this
пана Алеша
apartment.
Залежа.
Please ask your question.
I have a question with regard to this apartment, because what's the size of this apartment? I mean, why the price is so low? 13,000 hryvnias.
Thank you for your question, Mr. Alish. Such price was recognized by the Bureau of Technical Inventarization. You know, when I obtained the technical passport, the former owners, they stated the price 790 hryvnias, and this was because of the previous legislation. And there was, if you make as a gift, you give as a gift the price that is the apartment that is more than 500 Soviet rubles, it should be notarized. So I would say that neither me nor my parents nor my relatives, we could contribute to it, we could influence it. And also, as for the area that you asked, it is 90.1 square meters. Yes, it is actual information. At the year 2000, it was such an order in Ukraine. Now this order has been changed, and now we have other rules. Now there is independent market evaluation of the immovable property in the case of alienation. But if we talk about the contracts in between relatives, this evaluation isn't necessary, and sites by themselves state what is the value of this assessment, and they pay the tax on it.
Thank you.
Немає більше запитань?
Are there any other questions? If there are no questions, Ms. Oksana Volodymyrivna, please, you are given the floor for your closing remark. Up to 5 minutes. Dear advisory group of experts, dear members and their deputies of the AGE, dear representatives of the Secretariat, this selection procedure is very difficult one, but me and other representatives of legal society, we expected for such a selection procedure. I am specialist of the constitutional law for 21 years, and in my latest research about the methods of selection procedures for judges, number 7 from 2023, I analyzed different models of selection procedures, and I indicated that the model of selection procedure that we have for today, I mean certification method and integrity and competence evaluation, it is the best option. And I am so proud that I am present at this historic event, because this raise of the requirements for the future judges is proportional to the powers that will be assigned. Thank you so much, and have a nice day. Thank you, Ms. Oksana Volodymyrivna, for your answers to the questions. And for now, the interview with the candidate for the position of a judge of the Constitutional Court of Ukraine, Ms. Oksana Volodymyrivna Shcherbaniuk, is closed.